a Schedule 5 offence. If, with the permission of this Honourable Court, if we can ascertain from the State whether the application is opposed, and if the application is opposed, on what basis it is opposed. Apart from the fact that the burden of proof is on the applicant to persuade this Honourable Court that the interest of justice permits her release on bail. If it pleases Your Worship, we are in a position to proceed.
The State is not opposed to bail in this matter, Your Worship. The onus does still rest on the accused.
As the Court pleases, Your Worship, in pursuing or moving the application on behalf of the applicant, we will do so by manner of affidavit. We have a rather lengthy and voluminous affidavit. Would you wish to read same into the record? Thank you. May I hand you the original and then perhaps proceed from the copy in my possession?
Yes, please.
Court pleases. If it pleases you, may I proceed? In the Magistrates Court for the District of Soweto, held at Protea, in the matter between Makgotso Mapakiso Mofokeng, applicant, and the State, the respondent, affidavit in support of release on bail. I, the undersigned Makgotso Mapakiso Mofokeng, hereby state under oath that Roman Law 1 at introduction, paragraph 1, and the applicant in this matter, affidavit is made in support of my release on bail, which I submit will be in the interest of justice for the reasons as stated below. The facts contained here are within my knowledge and are both true and correct. I'm awaiting a bail application to be brought before the above-mentioned Honourable Court as a matter of urgency. My legal representatives have advised me that it is now considered law and practice that in bringing bail applications and to expedite the application, neither the offence nor the State has to present viva voce evidence. Still, it may rely on the mere production of affidavits and annexures. Paragraph 5. I've been advised to depose to this affidavit for purposes of my application to be released on bail. The content of my affidavit is based on my observations, knowledge, and legal advice obtained. I confirm that the respective meanings of the relevant legal terms and or legislation were comprehensively explained to me. Roman Law 2 at personal particulars, paragraph 6. I'm a South African citizen with identity number 86. 0829-0273-087 and am 38 years of age. Find a copy of my identity document attached here to marked annexure NNN1. I possess a valid passport which I will surrender to the investigating officer if the court orders me to. I did not have any, or rather I do not have any travelling documents of any nature. Find a copy of my passport annexed here to marked annexure NNN2. Paragraph 7, I reside at number 193 Gogo Avenue, Mondia, with my biological mother, my brother, and my 3 minor children, aged 12 years, 8 years, and 6 years, respectively. My husband and his daughter, my stepdaughter, also reside with us since we got married in 2024. I've been residing with my mother for the past 27 years. Find Annex here too, a copy of my proof of address of my business, marked Annexure NNN3. We are currently awaiting the completion of the restoration of a house I bought in Fairlands, Randburg, where we will move to upon completion. If I am released on bail, I will reside with my family at my place of residence upon completion, referred to Supra. 8. I married my husband, Sabelo Ngube, on 15 January 2024 in Johannesburg. A copy of our marriage certificate is attached here to and marked Annexure NNN4. Paragraph 9.1, I'm self-employed as a traditional healer and practice as such. As a traditional healer by occupation and as depicted from the copies of my passport, I travel frequently through Africa in search of conventional herbs and products. I therefore need to retain my passport and be allowed to travel abroad in search of traditional herbs not commonly found in South Africa. Previous travel to countries abroad includes in inter alia, Botswana, Namibia, Kenya, and Mozambique. I do not have relatives and reside outside the boundaries of South Africa. My parents were divorced in 2002. My father will turn 60 years of age in March 2025, and my mother, whom we reside with in Mondia, is currently 65 years old. Point 2. As already stated, I'm a traditional healer by occupation, and I'm presently employed by my company, G. Maweni Productions, Pty Limited, bracket, G. Maweni Productions, close bracket, with its main place of business at 193 Bilbo Avenue, Mondia. The business is therefore run from my residence where we all reside. I submit that I have 4 employees in my employment who will suffer if G. Maweni Productions is unable to generate any form of income. Find the relevant separate documents attached here to marked annexure M5. Once my new home is renovated, the business will be relocated to my home in Fairland. Point 3. I've been a traditional healer for the past approximately 15 years. I submit that I'm also regularly on TV and radio and have a reality show and a social media following of more than 1 million people. I do charity work and annually host a women's conference where well-known motivational speakers are guest speakers and different goodie packs are handed out to the audience. I also hand out food parcels at my home to needy people. I deliver sanitary pads to schools and hand diapers and baby food to children's and welfare homes. I also do frequent school drives in KZN where I buy school uniforms and shoes for needy children who cannot afford them. I do at least one event every 4 months on my social media, Maweni Cares, close bracket, is updated with pictures and comments of these events regularly. Point 4, I humbly submit that I'm a well-known person, not only within the local community, but countrywide. Paragraph 10, I respectfully reiterate that I have 3 minor children who reside with me. My children have no contact with their fathers, and none of their fathers contribute to their maintenance at all. All my children are dependent members on my medical aid. I submit that I'm the primary caregiver of my 3 minor children. My children are dependent on my daily physical, emotional, and financial support. I have a very close and loving relationship with my children. My arrest and subsequent incarceration have left my children extremely traumatized with an unbearable emotional burden. Paragraph 11, I submit that I'm pregnant with twins. I attach here to a copy of my ultrasound scan confirming that I expect twin babies, marked annexure M6. I pause to state that at Johannesburg prison, where I've been detained since my first appearance in court, I was again tested to confirm my pregnancy, whereafter they relocated me to the section for pregnant women. I am on a treatment plan to receive special medication for my pregnancy. This medication is essential to support my pregnancy and to ensure the best outcome for the babies. However, I am not allowed any prescription medication in prison, and the medication they supply me in return makes me nauseous and causes me to vomit. It also suppresses my appetite, which is not good for my pregnancy. I'm also required to follow a specific diet to support a healthy pregnancy. I attach here to the report from Vita Lab dated 20 January 2025 confirming my required treatment as annexure M7. I respectfully submit that my continued incarceration might result in a life-threatening situation for my unborn babies and me. Paragraph 12.1. I attended primary school at Crown Reef Primary and High School at Mondia High School. I matriculated at Maryvale High School, Orange Grove. 2. I generate an income of approximately 70,000 Rand per month from the proceeds of my company. As stated above, I do not receive any maintenance for the minor children from their biological fathers. I alone contribute towards their upbringing and maintenance. Point 3. I own the immovable property bought in Fairlands, Randburg, bracket 107 5th Avenue. I'm busy doing renovations to this property, and upon completion, we, bracket, me, my husband, and our children, close bracket, will move there too as a family. I also own a property in Deep Kloof, Zone 4. I rent this property and receive an income from the rent of 18,000 Rand per month. I also own a townhouse in Oakdean, Balboa Park, and my rent income from this property is 8,000 Rand per month. Point 4. The value of the immovable properties is approximately 4.5 million Rand. The properties are not bonded. Point 5. I possess movable assets, bracket, household furniture, fittings, and appliances, close bracket, of approximately 400,000 Rand, excluding personal belongings and clothing. I also possess a BMW 420i 2023 model with a market value of approximately 650,000 Rand, and a Ford Ranger LDV 2014 model with a value of approximately 300,000 Rand. The Ford Ranger is paid in full. Paragraph 13, I submit that my residential address is valid, fixed, and within the jurisdiction of the above mentioned honourable court where I will stand trial. My residential address should be common course between the state and the defence. 14, I have an amount of 5,000 Rand available for bail, but will be able to raise further funds with the assistance of my family and friends should the court find a higher amount appropriate. Roman law 3 at history of antisocial behavior, paragraph 15.1. I have the following previous convictions. Point 1, I was convicted of assault GBH in 2017 and was sentenced to a suspended sentence. Point 2, I was convicted of fraud in about 2015. I was accused of fraud by my employer because I passed the credit for product that I bought from them and did not let a different manager do it. As far as I can recall, I did community service for 3 months. I'm unable to recall the exact sentence I was imposed. Point 3, I also pleaded guilty to driving under the influence of alcohol approximately 15 years ago. I do not recall the sentence handed down, and a recent application for police clearance before traveling abroad did not reflect the conviction. Point 4, I mentioned to my previous attorney of record that I do not remember the exact details of my previous convictions or sentences. During my first court appearance, she may have mentioned that I do not have any previous convictions or sentences, although I am not entirely sure. I submit that I'm a lay person when it comes to court procedures, despite my previous encounters with the law. Your Worship will notice that 15.1.5, if you perhaps, if I may request you to turn the page, there's an inserted page at the back, and I will then return to the previous page, and I will then proceed reading from 15.1.5. Apart from the above, there might be further previous convictions that I failed to disclose. My failure to disclose is not the result of malice or to mislead the court. I submit that I never expected to be arrested and treated this way. I was extremely traumatized and confused because of my subsequent my arrest and detention. As a result hereof, I started bleeding. It appears that a misunderstanding between me and my previous attorney happened. I meant to say that I have previous convictions, but the nature and the detail thereof I could not recall. I unequivocally state that I did not intend to mislead the Honourable Court, as my freedom depends on this application. I then take you back to page number 8, Your Worship, 15.2. I do not have any outstanding or pending cases. Paragraph 16. I confirm that no order contemplated in terms of section 5 or 6 of the Domestic Violence Act 1998 has ever been made against me. I further confirm that no order contemplated in terms of section 3 or 9 of the Protection from Harassment Act 2011 has ever been granted against me. No orders of a similar nature have been granted against me. Paragraph 17. And I take you then, Your Worship, to page number 9. I am not placed under correctional supervision, day parole, or medical parole as contemplated by section 73 of the Correctional Services Act 1998. 18. I've been informed that failure to disclose the above mentioned aspects constitutes an offence. I'm aware of the consequences thereof. Roman law 4 at charges, factual background thereto. Paragraph 19. I've been informed that I stand trial on a charge of assault with the intent to cause grievous bodily harm, brackets GBH. Both my legal representatives and I have not been afforded an opportunity of access to the docket. I'm therefore unaware of the exact nature of the charges and or allegations made against me. 20. Should it be required to amplify any aspects contained in this affidavit, I wish to reserve the right to give oral evidence and or a further affidavit at a later stage in support of this application. I therefore reserve the right to request my case to be reopened to give effect to the aspects referred to supra. Point 1. I vehemently deny being guilty of any offence and will most certainly plead not guilty to any charge the state may prefer against me at my trial. I've been advised by my legal representatives that I have a constitutional right to remain silent and that it is indeed prudent to do so at this stage. I will, notwithstanding my constitutional rights, concisely tender the basis of my defence. Point 2. I submit that a detailed version will be placed before the trial court and during the trial procedures. Point 3. On the morning of 19 January 2025, the police went to my Fairland property looking for me. I was in Mondia at the time when they called me on my cell phone. The police then went to my Mondia residence looking for me, but I had already gone to the Mondia police station to find out why they were looking for me. Upon my arrest, I was informed that the SAPS could not get hold of me and that I was arrested for allegations of GBH allegedly emanating from an incident in December 2019. Point 4. I respectfully submit that I find it extremely strange that the police could never get hold of me. I'm a public figure and well known with a huge social media following. I have resided at the Mondia residence long before the day of the alleged incident. I emphasize that I've been residing at the very same address for approximately 27 years. I submit that the SAPS evidently had the details of my residential address, hence contacting me and looking for me at my residence. Point 5. I appeared before this Honourable Court on Monday 20 January 2025 and the matter was postponed to 27 January 2025, during which I was ordered to remain in custody until then. 6. The complainant in the matter is the cousin of my third son's father, Siabonga Zulu. Point 7. On the day of the alleged incident, I attended a public appearance in Soweto. The complainant and her friends or family were there too. About 5 people approached me in the street and started shouting and screaming at me. The verbal abuse turned violent and I had to defend myself against these attackers. Siege Zulu was one of them. My phone was stolen during the altercation. Members of the public intervened and pulled the attackers off me. I then left for my home. Point 8. At the time, I filed the criminal charges against the complainant and her accomplices at the SAPS. After having filed charges, I never heard from the SAPS again. Apart from phoning the police station on a few occasions, inquiring into my complaint, I did not pursue the matter. The incident transpired more than 5 years ago. The matter serving before the Honourable Court appears to be a classic example of 2 persons having filed counter charges against each other, wherein only one of the complaints is investigated and pursued more than 5 years after the fact. I submit that I was the victim in the matter and not the complainant. Point 10. The complainant and my third son's father, Siabonga Zulu, knew my details and whereabouts all along. 11. I vehemently deny having committed any offence of any nature. I submit that I raised a bona fide defence. I submit that the state has a weak case against me. I will in all probability be acquitted upon the conclusion of the trial. Roman law 5, submissions regarding factors to be considered when deciding whether bail should be granted. Paragraph 21. I'm advised that my application resorts within the ambit of Schedule 5 of the CPA as a result of the nature of the allegations and previous convictions. 22. I've been informed that if the Honourable Court finds that my application indeed falls within the ambit of Schedule 5 of the CPA, I bear the onus to prove that the interest of justice permit my release on bail. I respectfully submit I'm not required to prove the absence of factors different to normal considerations listed in subsections 4 to 9 of Section 60 of the CPA. Roman law 6, considerations in terms of Section 64 A to E, read for Section 65 to 68, capital A of the Court Procedure Act. Section 64, subsection 4, paragraph A. 24, I respectfully submit I do not pose a threat to the safety of the public or any particular person. I harbour no resentment towards any person and have not threatened any person in this matter. I submit that the allegations are serious. I submit that I'm presumed innocent until proven guilty. I respectfully submit that my release will pose no threat to society. I respectfully reiterate that I do not have any outstanding case. Section 60, subsection 4, paragraph B. Paragraph 29, I will not attempt to evade my trial. I submit that I'm a stable, contributing member of society and I'm not a flight risk. I'm a positive individual and in the process of getting the strings of life together again. I submit I'll be staying in a stable, contributing environment if released on bail. I understand that the charge against me is serious. A stern punishment may be imposed by the Honourable Court, trial court, if I am convicted. I, however, respectfully submit I remain presumed innocent and I'm confident that I will be found not guilty of the charges. 32. I will abide by any bail conditions the court should deem fit to impose. I submit that my pre-arrest conduct is indicative of the fact that I will stand my trial. I submit that my husband informed me that the police were looking for me. I approached the SAPS at the Mondia police station alone to inquire into the reason for the SAPS looking for me, whereafter I was arrested and detained. I submit if I had any intention to abscond or not to cooperate, I had adequate opportunity to. 33. I submit that my business is dependent on my daily input. I will in all probability have to close down my business down if I am not released on bail. Section 60, subsection 4, paragraph C. Paragraph 34, I respectfully submit there is no chance of any interference of any nature. I'm informed that relevant witness statements have already been obtained. I'm informed that the matter emanates from an alleged incident in 2019. Therefore, the investigation should have been completed a long time ago. 35, I will refrain from interfering with any of the state witnesses. Section 60, subsection 4, paragraph D. I submit that my release on bail will not undermine or jeopardize the objectives of the proper functioning of the justice system. I've not supplied any false information in this matter, and there is no indication in my past conduct to show that I will not comply with any of the bail conditions. Section 60, subsection 4, paragraph E. I submit that there are no exceptional circumstances present to indicate that my release will disturb the public order or undermine public peace or security. Roman law 7, at section 60, paragraph 9, or subsection 9, prejudice, the applicant is likely to suffer if bail is denied. Paragraph 39, conditions prevailing in prison are not conducive for human use. I will be unable to comprehensively consult with my legal representatives and will be prejudiced in the preparation of my defense and my subsequent trial. I submit that I will be severely prejudiced should bail be refused. I respectfully submit that my children are in desperate need of my physical and emotional support. They are traumatized by my incarceration. My incarceration has placed an immense emotional burden on my family. Due to my mother's age, she is unable to care for my children and their respective and specific needs. My health condition is not good, and for the reasons advanced supra. I'm pregnant with twins, unable to function in prison, and do not have access to my much needed medical treatment and medication. The prison does not cater for my specific dietary needs referred to supra. My continued incarceration might very well result in a miscarriage and a life-threatening situation for me. The circumstances prevailing in prison are simply not conducive for a pregnant lady like me. My condition renders me a soft target for criminal activities prevailing in prison. Paragraph 42. If I'm not released from custody, I will not be able to generate any income of any nature. My business requires my specific skills and daily input. I will eventually have to close my business down. My husband will be unable to meet our financial obligations, and my family will suffer and will be prejudiced. I respectfully reiterate that I have 4 employees in my employment. The employees and their respective families are dependent on the income they receive from Maweni Productions. My employees and their families will suffer undue financial prejudice if the business is unable to generate any form of income. I'm informed that trials, such as mine, might take up to 2 years to conclude. Even if I'm eventually acquitted upon the finalization of my trial, the detention will have a devastating and punitive effect on my life. I submit that no likelihood exists that any grounds referred to in section 60, subsection 4, paragraphs A to E of the CPA will incur. I further submit that the interest of justice can be found in my circumstances, the factors referred to supra, cumulatively assessed. I therefore humbly submit that I have indeed deduced evidence that it will be in the interest of justice that I'm released from custody. Request the Honourable Court to fix bail to an amount and with any appropriate conditions that the Court should deem fit. Paragraph 46, I will comply with any bail condition until the conclusion of my trial. Your Worship, it has been duly so signed by the applicant in the proceedings, and the application has been commissioned. If the applicant admits the contents of the statement, I will humbly request Your Worship to accept same into the proceedings as Exhibit A, as it pleases Your Worship.
Affidavit of the applicant, marked as Exhibit A.
As the Court pleases, thank you. That will then be the case for the applicant.
As the court pleases, Your Worship. Your Worship, the state has already informed the court that it is not opposing the bail in this matter. However, there are submissions that the state has, Your Worship. Firstly, the state has a bail statement that is being deposed to by the investigating officer. We would like to read that, Your Worship. I am an adult male, employed by the South African Police Service with service number 0529 599/8. I am stationed at the Gauteng Province Cold Case Investigation Unit at number 41 Gubiso Avenue, holding the rank of a captain. The accused in the above matter, Makgotso Mofokeng, is also known as Gogo Maweni, has previous convictions for the same offense she is now charged with. She was arrested and charged with assault with intent to do grievous bodily harm as per Kliptown case number 35/05 2017. The accused was then convicted on the charge and sentenced to 3 years imprisonment, which was suspended for 5 years. It is upon this ground that I oppose that the accused be released on bail, in that she committed this offense while under a suspended sentence for a similar offense. In a case where the court arrives at a different conclusion, other than the one that I prayed for, I wish that the court should put stringent bail conditions, and also that the accused surrender her travel documents to the state. That is all I would like to state for now regarding the bail proceedings. The statement to worship has been signed and duly commissioned. The state begs leave to hand it in for it to be marked as an exhibit. Support pieces. Your worship, the state is also in possession of SAP 69s of the accused. May we read that, your worship? On the 14th of October 2009, the accused was found guilty of contravention of the Road Traffic Act, was sentenced to a suspended sentence for 2 years. On the 29th of September 2017, the accused was found guilty of assault. The sentence was 1,500 rand or 3 months imprisoned, and that was wholly suspended for 5 years. On the 24th of July 2018, she was found guilty of fraud. The sentence was count 1 and count 2 taken together for the purpose of sentence. 20,000 rand or 6 months imprisonment, which was wholly suspended for 3 years. Again, on the 24th of July 2018, she was found guilty of fraud, and the sentence was also taken together for the purpose of sentencing. 20,000 rand or 6 months imprisoned, which was wholly suspended. Another count of theft on the 27th of July 2018, also taken together with the previous one. 10,000 rand fine or 3 months imprisonment, which was wholly suspended. Count 4 was of theft as well. 24 July 2018, also taken together with the previous ones. Your worship, the state begs leave to hand in the SAP 69s for them to be marked as an exhibit. Support pleases.
I'm just referring to this fraud and theft matter in 2018. It says 2018, 24th of July, fraud that committed 15 August 2016. Then it's printed again, page 3 of 4, 2 of 4, 3 of 4. Count 1 and 2 taken together. That is a duplicate. And then the next page 3 of 4, that is a duplicate. And then the same one, but then it says count 3 and 4. So it's count 1 and 2 taken together. Count 3 and 4 taken together. And then further in terms of section 276, 1H of the Criminal Procedure Act, usually sentenced to 12 months correctional supervision. So it seems that in 2018, July, the 24th, there was a charge of fraud, count 1 and 2, charge of theft, count 3 and 4. So it's unclear whether it was 3 and 4 alternative, but it sounds like it was fraud 1 and 2. theft, really.
Indeed. My inference from what the prosecutor placed on record was that his one case number, counts 1 to 4, 1 and 2 fraud, 3 and 4 theft. Yes, but it was one case.
One case,
Yes.
and then it was, I think altogether it was a 276.
That, yeah, correctional
One
supervision. 276 yes.
Was arrest and that was 12 months.
Correct. That is what I infer from the 69s as well. Thank you, Worship.
Just wanted to make that clear. Because there's a duplication on between page 280. When you read it. SOP 69 is not as
As the court pleases, Your Worship. Your Worship, the state would also like to submit that when considering whether it is in the interest of justice that the accused be released on bail or warning, Your Worship, that the court be reminded of the first appearance of the accused before this court. She was asked, Your Worship, she was legally represented, and her legal representative informed the court she had no previous convictions, despite the previous convictions that had been handed to this court. The state is of the view that this shows that the accused was dishonest to the court, Your Worship. And also to inform the court and the accused that the state will be adding a charge of failure to disclose. The court should also take into consideration the assault of 2017. It is a similar charge to the one that the accused faces today, Your Worship. And the investigating officer also mentioned this in his statement, which shows that the accused before court has a propensity of committing offenses, similar offenses in that case. Just after 2017, where she was on a suspended sentence, 2 years later, she finds herself having committed the same offense. This is something that the court should take into consideration when it makes its decision. Further to that, Your Worship, the state is in possession of an A1 statement, and just to reiterate that the complainant is well known to the accused, and after the incident occurred, there were threats that the accused uttered to the complainant. The state would like to read a short paragraph, Your Worship, to the court. It is A1 statement deposed to by Kulu Eliwe. Paragraph 4. My sister Mbali of 46 Salukanda Street, Zamini, heard the noise and then she came out immediately and she took me inside the house to clean myself. I then went to the clinic as my mouth was having a big cut. When I was at the clinic, Makoto followed me and she was insulting me there at the clinic, telling me that she fears nothing and she has the money to bribe the police to drop the case. This is also some information that the state would like the court to take consideration of, Your Worship. The threats that the complainant endured after this incident occurred. With that said, Your Worship, that is the state's submissions.
No evidence that the applicant today will endanger the safety of the complainant, although she knows the complainant. In the 5 years that the matter has been pending or in being investigated, there's been no evidence that the accused or the applicant has endangered the safety of the complainant. Subsection B, whether there's a likelihood that the applicant, if she was released on bail, will attempt to evade her trial. There was no evidence that she will evade her trial after she was contacted by her husband or by the police. She handed herself over to the Mondia police station. There was no indication that she will evade her trial. She has stayed for a period or resided for a period of 27 years in Mondia. so her address is well known. Subsection C, whether there's a likelihood that the applicant, if she's released on bail, will attempt to influence or intimidate the witnesses. There's no evidence today that she will attempt to influence or intimidate the witnesses or conceal or destroy the evidence, as in her mind that this case was not even being investigated. Subsection D, where there's a likelihood that the applicant, if she is released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. This matter was conversed with the counsel of the applicant today with regards to the fact that the applicant today did not disclose in her first appearance her previous convictions. In subsection 8, subsection A, the fact that the accused, knowing it to be false, supplied false information at the time of her arrest or during the bail proceedings. The applicant did not disclose during her first appearance that she had the following previous convictions. In 2009, on the 14th of October, she was convicted of driving under the influence of alcohol, and her sentence was postponed for a period of 2 years. In 2017, on the 29th of September, she was convicted of assault with the intent to do grievous bodily harm and was sentenced to 1,500 rand fine or 3 months imprisonment, which was wholly suspended for a period of 5 years. And in 2018, on the 24th of July, she was sentenced to 2 counts of fraud and 2 counts of theft from her employer, and she was sentenced to, in terms of section 2761H of the Criminal Procedure Act, and this was also not declared by the applicant. The state has decided to remedy this is to charge the applicant with a further count instead of just the count of assault with intent to of grievous bodily harm, to also charge the applicant with providing false information during her bail hearing. The council has also stated to the court that this was done during her bail hearing due to the fact that she was traumatized, and she then did not disclose this information to her legal representative. The court has accepted this explanation from the council and from the applicant. And subsection E, where in exceptional circumstances there is the likelihood that the release of the accused or the applicant will disturb the public order or undermine the public peace or security. There's also no evidence of such. Therefore, the court will grant the applicant today bail in the amount of 5,000 rand. Court will make strict bail conditions for the applicant. So would you be taking instructions on the remainder of her case, or are you only instructed for the bail?
For the moment, I will be requested to be excused, but my instructing attorney, Mr. Westhuizen, will in all probability appear.
Can I, with you, arrange a date for further investigations? He's not wrote.
Yeah, he's not right. So,
Can I arrange with you?
more or less, how long will the state
We are
be?
looking at, I don't know if we are ready for copies, or are we doing further investigations?
Investigations are completed.
Further investigations are complete.
What is the procedure? Will it then be postponed for purposes of disclosure? And
Yes, we will postpone
so that
today
will be
for
the
further
purpose.
for copies, and on the next occasions, copies will be given, and then matter will be transferred to a trial
Approximately 2 weeks?
suitable.
Any date in 2 weeks' time? If I'm looking at my calendar, if you don't mind. The 11th of February, the date is suitable to Mr. Westhuizen, sitting next to me.
It is suitable for the court as well.
Court pleases. Thank you, Worship.
Ma'am, you may stand up. The matter is now postponed 11 February 2025 for copies. Your bail is set at 5,000 rand. The court is making the following conditions: no contact with the complainant, direct or indirect. You have to inform the investigating officer of your itinerary when you leave the Republic of South Africa. You also have to inform the investigating officer of your date when you change your address and the address which you move to. Do you understand? Thank you. 8:30, court number 2.